Real people, real cases. This is Verdict Watch.
In the matter of the state of Michigan versus John Christmas II, 25167. And counsel, your appearance, please.
Good morning, Your Honor. Chris Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you. Mr. Christmas, your name for the record, please. You're muted, Riverview.
You had a request on me.
I thought I did, but that was maybe before it moved me out. I don't know.
Yeah.
Can you hear us, Your Honor?
Okay, now I can, yes. Please, Mr. Christmas, your name for the record, please.
John L. Christmas II.
All right, thank you. And counsel, as to the arraignment.
Wait, formal reading. My client stand.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, schedule this matter for a pre-trial on February 20th at
9
a.m. And counsel, as to bond.
Your Honor, in this circumstance, my client indicates that he does work full time. He does DoorDash, lives in Riverview with his grandmother. He has a strong family support system. He doesn't have any children, but I know that he does have some limited means regarding financial. So I'm going to be respectfully requesting, considering the nature of being a misdemeanor, consideration for a personal bond. Thank you, Your Honor.
All right, thank you. And detective, who wants to address bond?
Detective Sergeant Gentry, Your Honor.
Okay, all right. And what would you like the court to know?
There will be possibly additional charges stemming from this case pending chemical analysis pursuant to a search warrant. And it seems like alcohol was the main driving factor in this incident. So if the court wanted to do, alcohol testing or mandate something like that, I think that would be appropriate. And Mr. Christmas has expressed a desire for maybe seeking some sort of treatment for that.
Okay. And Mr. Christmas, where is it that you reside? You reside at the apartment?
Yes, ma'am. It's about a few blocks away from here.
I'm sorry?
Yes, ma'am. A few blocks away from here. Penbrook Apartments.
Okay.
Formerly Penbrook.
Okay, so sir, where is it you're going to be living if the court releases you?
If it's possible, I would like to go back home. If it's not, I do have a friend I can call.
No, there's not. That's why I asked where you would be going.
I'm sorry, I can't hear you. I apologize.
No, sir, it's not possible. That's why I asked where you would be going.
Okay, I can call a friend that lives in Lincoln Park, or I can call my father, sir. It wouldn't be an issue for me to find somewhere. Ma'am,
Okay,
I'm sorry.
No, sir. So, and where is it you work?
I DoorDash, ma'am. I've been doing that for a good 3 or 4 years now, consistently.
Okay, and so you were residing with your grandmother?
Yes, ma'am.
Okay, and sir, have you ever failed to appear in court for any reason?
No, ma'am.
And are you currently out on bond in any other jurisdiction?
No, ma'am.
Okay, so, and if you were to test today, sir, what would be detected in your system?
Excuse me, ma'am?
If you were to test today, what would be detected in your system?
I'm assuming alcohol, if anything. I do smoke marijuana, ma'am.
Okay. And so the court, the court has some concerns for the safety of Miss Christmas, your grandmother. The court also has some concerns, based upon the allegations that you do also need treatment. You're seeking treatment, sir?
No, when he said, if I'm allowed to speak, I don't want to interrupt you, man. So I'm sorry.
You may speak.
When I said that to them, I just said for a while, I know I just need to get some help for just like counseling, just to have someone to speak to. I haven't really had anyone to speak to for a while. I understand my grandma's tried to speak to me, not really get us help. I have asked her if we could both go to counseling together to solve family issues. But I do understand she's older, so she may not remember some of the things I say sometimes, or she just wants to enjoy what she has going on for right now. So I just want to take responsibility, if you allow me to get out today to go get help and just go seek a counselor. I just need someone to speak to. I've been doing a lot on my own for a long time. I think it's just it's kind of just trying to catch up to me. I don't want to end up in here on a regular basis because I'm not a bad person, man.
No, sir, I'm not saying that you're a bad person. However, it appears as though you have some unresolved issues, as you've stated, and that is contributing to some of these behaviors. So what the court's going to do you have $350, sir?
Yes, ma'am.
All right, the court's going to order a $3,500 10% bond. In the event you sponsor, you're not to have any contact with Geraldine Christmas. That's phone contact, text message, email, social media, third party, anything of the like. You are not to return to the apartments, the premises at all, with the exception of one visit accompanied by a police officer to obtain personal belongings. You're not to possess or consume any alcohol or drugs unless prescribed. You will have an alcohol tether. The court, do you have an additional $180, $190, sir?
I'm not sure, man. I would have to check my phone account.
Okay, because the court will allow you to do that through EMS tether, which means that they'll come to the police station there and they will affix you with an alcohol tether.
I understand that, man. I understand your choice right now, and I respect it. But I also feel like I am not that type of risk for that to be needed. I'm not trying to go against anything you're saying. I'm just trying to state how I know I am, especially with me being honest with you. I'm not a bad person, man. I love my grandmother. That's the only person who's been taking care of me for all this time. I really don't have a big relationship with my main parents. I haven't talked to my mother in a long time. So that is really the only person that's pretty close to me. And like I said, I just want us to be able to go get counseling together, and or not even together, maybe just me, but I don't feel like no contact is needed in this situation. I can honestly say to you, I understand how it looks on paper, but
All right, so
I
at
do
this
care
point, I
about your
think
mother.
that there's been ordered by the court, and just so you know that in most cases like this, no contact provision is solidified. The court has made its order. We appreciate your comments. It's not going to change anything. As your attorney, I'd advise that you stop talking at this time.
All right, thank you. And sir, I did hear what you had to say, but at this point, these are the orders of the court, the conditions of the court's order. So you are not to possess or have access to any firearms and or any weapons. Do you have any of those, sir?
I've never had a gun in my life, man.
Okay. All right. So we'll see you back on February 20th, 9 a.m. So you will not, even if you post-sponsor, you're not to be released until EMS gets there to affix the tether. Okay?
Do you know?
Yes, sir.
Next case on the docket.
In the matter of the state of Michigan versus Lauren Miller, 241756. And detective, your name for the record, please.
Good morning, Your Honor. Detective Steve Sabo.
All right, please raise your right hand. You solemnly swear from the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am, I do.
All right, thank you. You may proceed on the warrant.
Thank you, Your Honor. On December 8th, 2024, at approximately 2:25 in the morning, Officer Kyle Cox and Officer Alex Stathakis, were dispatched to the Thirst Parlor Bar, which is located at 500 Ford Avenue in the city of Wyandotte, in the county of Wayne, for disorderly conduct, disorderly persons out in the parking lot. Upon officers' arrival to that location, they did discover and make contact with Lauren Elizabeth Miller, 719 of 85. She was highly intoxicated. The officers interacted with her and found out that she had skipped out on her bar tab after her credit card was declined and tried to get in her vehicle and leave. The officers investigating asked for identification, and while Ms. Miller opened up her purse, she had 3 medication or prescription bottles with worn labels on them. She produced her identification as requested. The officers asked if she had any contraband. She said no. They asked for consent to search her purse, and consent was given. And in one bottle, 38 white oval pills marked with M367 on an unreadable label. We looked up at evidence.com or drug.com, shows that it was hydrocodone, a Schedule II drug. 2 other medication bottles. One had a crushed powder in it inside a cellophane bag that Miss Miller said that was her prescribed Adderall that she put in the container herself with a worn label. The medication bottles were secured. Miss Miller was going to be arrested and advised, and during the handcuffing with Officer Stathakis, she resisted and tensed and squirmed her arms, making it very difficult for the officer to handcuff her. Again, she was highly intoxicated and disorderly out in public in a parking lot, and had these narcotics that I confirmed she has 0 prescriptions of any kind on a MAPS request after her arrest. Thank you, Your Honor.
All right, thank you. Upon examination of any witness, the court does find that the offenses charged were committed. There's probable cause to believe the defendant committed those offenses. Thank you very much. Would you like this returned or mailed?
Mail, please, Your Honor.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.